Welcome to Tanong kay Lu, Sagot ni Lu. Let's talk with solutions. Today, we're diving deep into the sticky issues of business law. Get ready to untangle the knot of confusion, expose the tactics of unfair competition, and shine a light on the headache of infringement. Let's get started. To begin with, our first client's question. Attorney, my company, Pure Springs, sell bottled alkaline drinking water, and we hold a registered trademark on our name and distinctive Blue Mountain logo. A new company has just launched an identical product, bottled purified drinking water called Pure Springs, using a very similar wave logo. They are placed next to us in every grocery store. Our sales are already dropping because customers are mistakenly picking up their bottle instead of ours. Isn't this a classic case of confusion of goods? And how do the other types of confusion play into my overall claim against the copycat? So, to answer your question, you are absolutely correct. Your primary claim against Purity Springs is a classic example of confusion of goods, or what we call product confusion, which is the most direct form of trademark infringement as it addresses the gravamen of the offense or the likelihood of confusion head on. So, first, let's discuss what is confusion of goods. Your situation perfectly fits this type because the products in question, the bottled alkaline water and the bottled purified water, are competing goods that are sold side by side to the same consumer base. So the similar marks are inducing the otherwise prudent purchaser to buy the infringer's product, which is Pure Springs, when they intend to purchase yours, Pure Springs. So this causes a direct and measurable damages due to misdirected sales. So let's talk about the second type of confusion, or what we call the confusion of business, or what we call the source of origin. So while your claim focuses on direct competition, the infringement also creates confusion of business, or the source of origin confusion, even if the competing product had a slightly different flavor or size. Consumers seeing the similar mark would be led to believe that Pure Springs is a line extension or an authorized subsidiary of your company. So the public is deceived into believing there is some connection or affiliation between the two entities that simply does not exist. So this broadens the scope of the infringement beyond just the point of sale. So, the last type of confusion is the confusion as to reputation, or the damage multiplier. So, crucially, we must incorporate confusion as to reputation into your claim, as this helps secure stronger remedies. So, this type of confusion arises from the similarity in the overall general appearance and logo. So, for example, if the infringer water is later found to be substandard quality, or they are associated with poor environmental practices. So your luxury brand's reputation could be severely tarnished. So the public, reasonably assuming the Pure Springs product originated from the same source as your established high quality Pure Springs brand, so it will transfer that negative association to you. So the risk is not limited to the goods themselves. It includes the inevitable confusion of reputation, which is often the most significant long term harm to a valuable trademark. So, to conclude, your instincts are absolutely correct. The similarity between Pure Springs and Purity Springs is a classic example of a trademark infringement. So, by proving that consumers are experiencing confusion of goods, which leads to loss of sales, and reasonably believing the product shares a common source, or what we call confusion of source, we build an undeniable case. We are not just arguing that they copied you. We are demonstrating the real and measurable harm this confusion is causing your business and brand. So the legal strategy is clear, and we are well positioned to protect your trademark. So, for our next episode, we will dive deep into the remedies available to you. Don't go anywhere, we will be right back. So, welcome back to our new episode. Today, I've got a great question. This is from a client who owns a trademark Speedigo for their popular scooter brand. They are facing a classic case of alleged trademark infringement. A competitor has launched a product called Spedgo using a clearly identical logo and same colors, causing their customers to buy the wrong item. So this situation screams likelihood of confusion. This is the heart of trademark law. Today, we're going to break down exactly what this trademark owner needs to prove in court, especially the legal test that is measure consumers' confusion and most importantly, the powerful remedies available to them, from shutting down the competitor's sale with an injunction to recovering every penny of their lost profit. So stay tuned. I want to clearly outline the powerful remedies that are available to Speedy Go as the trademark owner against the unauthorized use of his mark. So first, we will pursue a civil action for infringement before the competent court to enforce the rights and recover Speedy's losses. So our immediate priority is of course to stop the financial harm and market confusion while the main case is being heard. So we will file the following provisional remedies. First, the preliminary injunction. So we will petition the court for an order immediately restraining the rival from making, selling, or offering or advertising the infringing SpedGo scooter during the entire duration of the lawsuit. This is an essential for stopping the bleeding of Speedy's sale. Second, we will request an order allowing us to confiscate all sales invoices, promotional materials, and documents that is related to the infringing activities. So this documentation is crucial for calculating the full extent of the damages. And lastly, upon a favorable judgment, we can obtain a final order for the disposal or destruction of all the infringing scooters and means used to manufacture them, ensuring the infringement cannot resurface. So Spedigo is legally entitled to recover all the damages that they have sustained as a result of the infringement. So this includes attorney's fees and litigation expenses. So the measures of damages will be calculated to maximize the Spedigo's recovery based on the highest of the following. First, loss of profit. So the reasonable profit you would have made had the infringing sales not occurred. Second, the infringer's profit. So the actual profit the defendant made from the illegal infringement, and lastly, the reasonable royalty or a reasonable percentage of the defendant's gross sales used if actual profits are difficult to ascertain. So, crucially, we will pursue double damages. If we can demonstrate to the court that the rival had an actual intent to mislead the public or defraud the company. So the court has the authority to award speedy costs and double the amount of the actual damages. Lastly, be aware that your action is not limited to civil compensation. Depending on the evidence, the infringer may also face a separate criminal action upon conviction. So this carries severe penalties, including imprisonment 2 to 5 years or a fine of 50,000 to 200,000. So here we will assess the evidence to determine the best strategy for initiating both civil and, if warranted, criminal proceedings to ensure the infringer is held fully accountable. So, welcome back. For this, our final episode for today, we're diving into the two pronged defense every company needs against product piracy and brand theft. We're talking about how to protect your name and your packaging. Especially, we will be covering the essential loss of trademark infringement and unfair competition. Stick with us because understanding the crucial differences between these two claims is the key to locking down your brand's future. So, as to the question, does this conduct constitutes both trademark infringement and the separate offense of unfair competition is a critical one? The answer is an emphatic yes. So, this situation is a classic and powerful example of dual liability under the intellectual property law. So, let me break down for you exactly what the rival has done and why they have exposed themselves to two separate and severe legal challenges. So first, we target the registered name. You own the registered trademark Ultra Battery. The rival has launched Ultra Power. So the law on trademark infringement does not require a photocopy of your mark. It requires a colorable imitation that is likely to cause confusion. So here, the imitation, or by selecting the dominant and distinctive prefix ultra and applying it to an identical product, a high performance car battery, they have created a colorable imitation. So the word sounds familiar, they look familiar, and in the noise of the marketplace, they are nearly indistinguishable to the average buyer. Second, as to the confusion, so they have concrete evidence of customer already suffering confusion of goods. So that fact alone is the most persuasive evidence we can bring to the court to prove infringement, and they are trading directly on the goodwill that they have painstakingly built into the ultra designation. So second, the claim of unfair competition or the attack on the package. And just as important, we target the fraudulent scheme. This is where the law of unfair competition comes into play. This claim is broader and focuses not just on the name, but on the entirety of their deceptive act, what we call passing up. So the rival did not stop at the name. They copied your entire get up. The identical size, the exact color scheme, and the very style of the packaging. This action meets the first essential element of unfair competition, confusing similarity in general appearance. This goes beyond the word mark and protects the overall aesthetic identity of your product. And second, as to fraud, it also meets the second essential element, the fraudulent intent. When a competitor makes a direct copy of all the non-functional design features, the only logical and legal conclusion is that they intend to deceive the public and steal your sales. So a court will infer this fraudulent intent simply from the act of the slavish and wholesale copying. So, while we will file suit on both grounds, you must understand the key legal differences because they dictate our strategy. Let's differentiate trademark infringement and unfair competition. As to what is protected, under trademark infringement, what is protected is the exclusive right to the registered name itself. On the other hand, in unfair competition, it is the goodwill associated with the entire product presentation. As to the registration status in trademark infringement, it is mandatory. It requires your mark be registered. On the other hand, in an unfair competition, it is irrelevant. It means it protects the business's goodwill regardless of mark registration. And lastly, uh, to the intent requirement. In trademark infringement, it is unnecessary. Honest mistake is not a defense. Confusion is enough. In unfair competition, it is essential. It requires proof or inference of fraudulent intent to deceive. So the brilliance of this dual approach is that it is a belt and suspender strategy. If the court finds the name Ultra Power is not a trademark infringement, we still have the power to file unfair competition claim based on the copying of the size, color, and packaging. The opposite is also true. So what we are going to do here is that we will going to file an injunction or a court order forcing them to immediately stop the sale of the Ultra Power battery and the use of the infringing packaging. And second, we're going to seek full financial recovery for the profits that Ultra Battery lost and the profits they unlawfully gained from the deceptive scheme. So this is a solvable problem. We have the law and the facts on our side. We will protect your brand and we will ensure fair play in the battery market. And that brings us to the end of the line for this episode and for the season. Thank you so much for tuning in. I truly hope you pick up a new legal gem or two today to help you protect your business. And don't forget to review your brand's trademark registration and its overall trade dress. Because being cute is one thing, but being legally secure is everything. Until next time, keep competing fairly, and we'll see you then. Bye for now.